I beg to mention for listing one item, Lordship, criminal petition tomorrow, Lordship. Because NBWA has been issued, Lordship.
Yeah, yesterday I went home at 7:10. No time at all. 7:10, I went home at 7:10.
Seven,
So many cases. 7:10. I went home at 7:10 yesterday. No time at all.
Maybe, my lord, I have to mention for listing and IA, my lord, criminal, because my lord, notice was served, my lord, but still that not listed. So, my lord, condemnation petition, my lord, so there are charges, my lord.
After April or did first week?
May it please, your lord, I'm paying for listing of a bail application. Petition is behind the work for tomorrow, my lord. If for
How many days?
20 days in 379. Day after tomorrow, my lord.
Day after tomorrow is hearing day. What type of theft?
Snatching. Detail. 30.
Monday did
30.
on Monday.
May I please, your lordship, in admission lordship, I'm praying for an admission matter. Any day convenient to your lordship.
Next week, next month.
Second April, I have some difficulty.
May I please, your lord? My lord, I am praying for listing a criminal appeal on 24, my lord, this month.
Oh, wow.
24.
Why
24.
on 24? Why?
My lord, the conviction is only 7 years, and he's, my lord, undergone already 2 years, my lord.
Under which sections?
Under section, my lord, 376.
Next month.
More than
yeah.
2 years, my lord.
Next month, we are giving you a date. Next month.
My lord, another pair, my lord, IA, my lord, in criminal division petition, my lord. My lord, it may be taken up on 24, my lord.
Criminal revision
For
petition IA.
conviction. IA for continuation. Oblige.
May I please, your lordship? Lordship, I beg to mention for listing of one criminal petition in admission column. Any convenient date this month, lordship. Matter has not been listed since July 2024.
28th of March.
May I please, your lordship, I beg to mention one criminal appeal to come up on the next week, my lord, for hearing.
Old appeal.
Appeal, my lord, criminal appeal.
Next week for hearing. I think there are too many cases for hearing. Not next week.
25th March, my lord, Tuesday,
3rd of April.
3rd of April.
Please, your lord. Please, your lord. So I beg to mention, Lordship, I'm praying for listing a criminal revision for order school, my lord. It is now listed on 27/7/2024, but not reached. However, directed them for listing the matter within 3 months. But petitioner they are here in my lord or
Okay,
government
okay,
employee. On
okay.
24, my lord.
Not on 24th. On 28th.
26, my lord. 26.
26 fine.
I have similar pair, my lord, listing of 2 criminal petitions for orders, my lord. First week of April, my lord, it permits, sir. Deeply
May
obliged.
it please, your lordship, I beg to mention listing a criminal revision petition, lordship.
Oh, what mother? Welcome to the company. Oh. Madam, looking for you.
Mention for listing of a criminal petition 974. Lordship. It was last listed on 7th August 2014. 24. Lordship. Next week, Lordship.
Criminal revision petition.
Criminal petition. Lordship.
Criminal petition. Next week, supposedly for a novel April or did 1st of April.
May it please, your lordship, I beg to mention listing a criminal revision petition, lordship, next week, lord.
2nd April.
May please, your lordship. Lordship, I beg to mention item number 31, lordship. Item for the lordship. But here CD receipt.
You are on interim bill?
No.
31. Learned counsel, Mr. What is your name?
AK Kanu.
Huh?
AK Kanu.
AFA Mullah.
AK Kanu. Kanu.
On behalf of whom?
No, my lord. This one.
31.
He made a mistake. Yes, mistake. Wrongly mentioned, lordship. This is not it. And I will lordship, I beg to mention for listing on BA.
BA.
On
and the last listed on 18/12/2024, my lord. I have put it, directed the petitioner to submit, to file affidavit, my lord, to bring the order of having charge, my lord. Already charged them on the last 1/1/3/2020.
NDPS case,
No, my lord.
POSCO,
No, my lord.
murder case.
Yes.
When do you want?
Day after tomorrow.
No, no. হেৰি next week হ'ব নেকি চোৱাচোন 27th, on 27th.
28, 25th, my lord.
25th হ'ব নেকি? No, no, not on 25th. Not on 25th.
27.
Yeah.
Okay.
May I
Yes.
please, Lordship?
Yes.
Lordship, item number 49, this is a hearing matter, Lordship. Lordship, if possible, it should be taken up at 2, Lordship.
Hearing matter at 2.
Two.
Today is a hearing day, definitely. Yes.
Cannot read.
বেলেগ আছে নেকি 2? Yes, we can take up at 2.
May it please the Lordship. Lordship,
Item number 14, no?
49.
49. It's a hearing day, we should take up at 2. Yes.
Okay.
I beg to mention, filing serial number is 2440/25, Your Lordship. This case is very important, Your Lordship, because the accused person is under the custodian, he is under treatment, Your Lordship. So kindly matter may be taken up tomorrow, Your Lordship. And
Fire নেকি tomorrow? Treatment আছে. On Friday,
Lordship, Friday is not possible. Kindly tomorrow, Your Lordship, please, Your Lordship.
on 24th, Monday. Monday.
Tomorrow, Your Lordship.
Treatment আছে tomorrow নহ'ব না?
Under the treatment, Lordship, he is very serious condition.
Was a prayer for listing of a IA in a criminal case.
Hmm.
Is a conviction matter. So it may be taken, it has not been taken up since last 1 month.
Hmm.
It was being listed after 2 weeks, it was being passed, it's not being listed. So Dr. may kindly take up the matter within this week.
I cannot hear you properly. I cannot hear you.
It's a IA,
It was listed on last listed
it
on
was listed 1 month before,
I relating to what?
criminal appeal. So
Appeal under which sections?
it is a 10 years in prison, 304.
304. To হেৰি
Objection is also
April,
filed.
yeah.
Objection is
2nd of April. 2nd of April.
before the first.
Appellate, Lordship, I beg to mention for listing on regular bail applicant. Same matter fixed tomorrow.
Same matter fixed on?
Tomorrow, Lordship.
May I please, Your Lordship, I beg to mention item number 47, Lordship. Senior counsel XKC could not come from test to Lordship. Any matter may be fixed on 22nd April.
Yes.
My lord,
On
item
22nd April.
My lord, this matter, item number 47, several times, my lord, the petitioner appellant side has taken the time without taking my information, my. Today also, my lord, I am waiting for it. Need to কোৱা নাই ন?
ফোন কৰিছিলে
তাৰ আগতেতো বহুতবাৰ লৈ গৈছে my lord. So this matter may be kindly taken up today, my lord, at 2 PM, my lord. 2 or after.
At 2 PM, we have already fixed the matter and she has left.
My lord, I have from the respondent side, Pompi Sharma, she has asked me to update the matter, my lord. And for the last year, my lord, I am trying to dispose the matter, my lord, by without any cause. They have taken the time, my lord, and I have taken.
Lordship, I'm
mentioned
not in
sleep.
this case.
I have-
Counsel
I
is
meant-
not available.
Where is
I
he?
am taking the matter by mention memo by Registrar General, my lord.
Where is he? Where is he?
My lord.
Test to Lordship.
He's
My
in
lord,
test pool.
several times without any cause, without any reasonable ground, you have taken the time without giving information, my lord.
Last is
We fix a date early, not
22nd April, Lordship.
why 22nd April?
As per instruction, Lordship.
He's from Tezpur.
Yeah, yes, Lordship.
মনে মনে এনেকে টাইম
ফোন
লোৱাটো
কৰিছে
নহয়।
মোক জনাইছে ফোন কৰিছে
7-8 times, my lord. Your lordship kindly see the order sheet, my lord. How many they have taken the times, my lord. And I have several times I mentioned sleep. I am
But I am
this
not in
case
this
is
case,
listed, my lord.
All I'll pass a speaking order. Learned Counsel Miss
M. Borwa, Lordship.
M. Burwa on behalf of Learned Senior Counsel Mr. S.K. Singh has prayed for adjournment as the Learned Senior Counsel resides in Tezpur. The learned counsel Miss B.R. Sultana for the respondent has laid The learned legal aid counsel, learned legal aid counsel, Miss B.R.A. Sultana, for the respondent number 2 has raised serious objections stating that several adjournments have been procured by the petitioners, and the petitioners have been dragging this case. Full stop. A last opportunity is accorded for hearing, failing which necessary orders may be passed.
So my death may be fixed, my lord. Death may be
Release the matter on 22nd April.
22nd.
Must apply.
Must have.
May please the lordship, I beg to mention for listing of a criminal petition, my lord, which is pending, my lord, on last listed on 11th of February, my lord. On next week, any date, my lord.
For April of the year. 4th of April.
What of it? I'm all right.
May I please the lordship, item number 19, for the journal.
19.
19, 19.
Lordship,
Interim is there.
1999 for the respondent. The date may be fixed. It is a case of maintenance.
Interim is there. Interim may be continued.
Hmm?
Interim may be continued.
The date may be fixed.
Learned counsel Miss
Eight Khatun.
A. Khatun has prayed for adjournment. Learned counsel Mr.
J.I. Mundal.
J. Mondal is present on behalf of the respondent. List the matter on date to the day of interim order shall remain in force till then.
Obliged.
May I please the lordship? May I please?
Hmm.
I paid for listing 2 interlocutory applications for bail, that's already pending, my lord.
Hmm.
Before the honorable court. Or next week if possible.
April of the day of
2 cases, my lord.
2nd April.
2 cases.
May I please, Lord? Lordship, I'm praying for listing of a bail application tomorrow for withdrawal. Lordship.
May I please, lord? My lord, one bail petition was kind of fixed yesterday, my lord, but not listed, my lord. And, from the same city, my lord, one bail case is fixed on the 20th March, my lord. So that this matter may be fixed on 20th March, my lord.
20.
20.
Okay.
Yes, apology.
So may I please, your lordship, I beg to mention one anticipatory bail application 513/25. Lordship, withdrawal for petitioner number 2 and 3, they were arrested on 13/3/2025.
What about one?
Lordship,
You're praying for withdrawal for petition number 2 and 3. What about petition number 1?
Lordship, the application is the anticipatory bail application. There are 5 accused. 2 accused were arrested on 13/3/2025.
So their remaining 3 are on interim bail,
No, Lordship.
not on interim bail. Date of the detail? 28th of March. Not before that. This is A, B only. You are not arrested. 28th of March.
Maybe. My lord, I beg to mention, my lord, for listing, my lord. As per last order, we are expecting for listing the first week, my lord. But unfortunately, my lord, matter could not list that, my lord. And it is, my lord, on 20 or 21st, my lord, this week, my lord, kindly. It's relating, my lord, anticipatory bail, my lord. It is here, my lord.
No,
Otherwise.
not on 28. 28. You are not behind bars. I don't
Hello?
have enough space to accommodate anybody.
No, we are not on.
You're not
interim.
behind bars.
We are not on interim, my lord. That's the problem, my lord.
I have given later dates on people who are behind bars. 28 March.
Applies, my
Please, your lordship. Lordship, I beg to mention for the listing of a bail application for withdrawal, lordship. Can it be taken up today?
Today, not possible. Tomorrow.
Obliged.
May I please, your lordship, item number 4, lordship, exam 4010 matter may be taken on Friday, lordship.
Friday. Niki? Not on Friday. Next week. 28 March. Learned Council Miss A. Begum, no?
28 March is too late, lordship. Today, 24 March, lordship.
No, not possible. 28. Learned Council Miss A. Begum has prayed for adjournment. List the matter on 28 March.
May it please, your lordship. I beg to mention for listing, lordship. Matter relates to quashing of criminal proceeding, lordship. So in lower court date 29, lordship, can it be listed on 25?
Fine, 29 or ago. 27.
Obliged, lordship.
My lord, I'm sorry, my lord. My lord, I have made a mention for listing of a criminal petition on 4th of April, my lord. The lower court, it was fixed on 1st of April, my lord. NBW has been issued, my lord. Can it be on before 1st of April, my lord?
27th.
I'm deeply of it.
Item number 1.
Item number also, we have taken an instruction the service. They have received a copy of the notice, but with the services and written of the, we have taken instruction. Can copy this. Box below. The fix another topic, we will take the instruction.
You have received the status of the case.
Received the, that I have confirmed us that they have received the notice,
Uh,
but whether service is completed or not, that is not yet.
but status has been received.
Received.
Learned Counsel Miss
Mdeka.
M. Deka is present for the petitioner. Learned Counsel Mr. D.P. Goswami has submitted that. What was it?
Notice
Ah.
notice was received by the concerned police station.
That notice was received by the concerned police station, but whether the notice has been served,
Served or not, that is not. yet.
but but there is no,
We have not received any instruction regarding.
but there is no
the served or
instruction
not.
whether notice has been served to the respondent number 2. Full stop. Await for service report on respondent number 2.
Get the details.
Have you received the scan copies?
Can copy I see. I have. Positive mind.
Call for the scan copies of the trial court record along with the scan copies of the CD. Please the matter on 7 April. 7 April.
When it is too long.
আগৰ দি দিয়কচোন।
Can copy.
4th of April.
Can copy I have.
Item 2.
Diary may be followed.
Call for the case diary, list the matter on
27.
Huh?
It's on 27 people.
27th.
I'm okay.
Item 3.
May I have the secretary? Lordship, relying on the judgment of the Honorable Apex Court, my lordship, page 33 may be seen, my lordship. I have. There are 16 minutes. After deep consideration of the matter, we proceed to supplement the proposition laid down by the Constitution bench in Anthony's case with
Page
full-
32, para 16.
Yes.
There's no para 16 in page
page
30.
33. Page 33.
Yes.
After
Please read.
deep consideration of the matter, we proceed to supplement the proposition laid down by the Constitution bench in Anthony's case with the following direction. That is the first one. In cases where the trial is for an offence punishable with imprisonment for a period not exceeding 7 years, whether the accused is in jail or not, the court shall close the prosecution evidence on completion of a period of 2 years from the date of recording the plea of the accused on the charges framed, whether the prosecution has examined all the witnesses or not within the same period, within the said period, and the court can proceed to the next step provided by law for the trial of the case. My lady. In the instant case, my ladyship,
Mhm.
have pleaded guilty on 9/9/2022, page 16 may be seen. Page 16, 9/9/2022.
এটা কলমটো লিখা নাই ব্লু লিখা নাই পেজ 20 পেজ 16
16. Dated order sheet, my lordship. 9/9/2022. Accused
লিখা নাই কিবা
present persons are present. Copy is ready and the same is furnished to the accused person. It is the case record had. Finding sufficient materials against the accused person, charges under section such and such have been framed, read over and explained to the accused person to which they pleaded not guilty and claimed to be tried. Issue summons to the prosecution witness. Thereafter, my ladyship, from 9/9/2022 to 2024, continuously several summons has been issued but the prosecution witness had not appeared, my lordship. Thereafter, I filed a petition, page 25. Page 25, copy of the petition, relying on that judgment, my lordship.
Hmm.
Page 25. This is my petition, my lordship, to
Hmm.
close the prosecution witness.
Hmm.
However, I am the learned trial court passed the impugn order on page 35. Page 35. Page 35 is the impugn order.
Hmm.
Party portion, page 37. Again, NBW, BWA has been issued against the accused, against the prosecution witness. So this is clearly in violation of the direction of the Supreme Court, my lordship. That's why I have approved before.
This punishment is for 7 years.
Less than 7 years. Ma'am. The prosecution evidence should be closed and the case should be proceeded to the next step. My plea is that.
Please read the order.
Hmm.
Page 35, please
Yes,
read.
yes, ma'am.
Please read the order.
Today is the date fixed for hearing of petition number 5821/2022-24 and prosecution witness evidence. No report has received. Learned counsel of the accused has submitted that accused is a government employee and prosecution has failed to bring the prosecution witness before this court, and as such accused person needs to be acquitted. The defense relied on judgment passed by the Honorable Supreme Court in the case of Rajdev Sharma versus State of Bihar on 8 October 1998 has made it very clear. In the said judgment, the Honorable Supreme Court held in cases where the trial is for an offense punishable with imprisonment for a period of not exceeding 7 years, whether the accused is in jail or not, the court shall close the prosecution evidence on completion of a period of 2 years from the date of recording the plea of the accused on charges framed, whether the prosecution has examined all the witnesses or not. With on the said period, and the court can proceed to the next step provided by law for the trial of the case. Situated thus, it is clear that this court cannot look into the documents furnished with the Learned Defense Counsel. On the other hand, Learned APP has submitted that accused cannot be acquitted on the ground of prosecution witness has not turned up. Now the case is at the stage of trial and this is a warrant procedure case. Hence, the accused petition under section 256 of the CRPC is not maintainable. My ladyship, here the ground is stated that this case is a warrant procedure case, but in the judgment, my lordship, there is no, it has not been stated that that in a warrant procedure case, this.
We'll go to the judgment. Please read the order.
Yeah, yes, fine. Judgment 33.
Please read the order completely.
My lord. He further stated that hence the accused cannot be acquitted. He further stated that BWA was also issued to prosecution witness, namely Azizur Rahman Lashkar and Abdul Ahad Lashkar, for non-appearance before this court. Peruse the case record along with the petition. The said petition was filed under section 256 of CRPC. The section 256 of CRPC deals with consequences of non-appearance or death of a complainant reads as follows. Section 256, non-appearance or death of complainant. My lord. If the summons has been issued on complainant and the day on the day appointed for the appearance of the accused or any day subsequent thereto, to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein before contained, acquit the accused, unless for some reason he thinks it fit proper to adjourn the hearing of the case to some other day. Provided that where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. Second paragraph. The provisions of subsection 1 shall, as far as may be applicable, also to cases where the non-appearance of the complainant is due to his death. Upon perusal of the case record, it is seen that the case was registered and charge sheeted under section 341, 325, 294, 34 IPC, and charge was also framed under 341, 325, 294, 34 of IPC against the accused person. The power conferred under section 256.
All right. Please go, let us read the Supreme Court judgment.
Yes, ma'am. Page 33.
Hey, read it.
Partition, page 30. After deep consideration of the matter, we proceed to supplement the proposition laid down by the Constitution bench until this case with the following direction. In cases where the trial is for an offense punishable with imprisonment for a period not exceeding 7 years, whether the accused is in jail or not, the court shall close the
Where are you reading?
page 33.
Page 33 you have read?
Yes, page 33 is the operative portion of the.
No, but we'll have to start from the relevant portion.
Yes, page 33 is the relevant portion. This is the guide. This is the proposition.
No, this is not the relevant portion. This is the finding.
Fine. Page 33, para 16.
Now, this is the finding, but what is the story here?
My lord.
In the Supreme Court judgment, what is the story here?
Yes.
Can you summarize the story?
According to my lord, according to the charge sheet, there are many as many as 40 witnesses, out of whom the prosecution has examined in today only 3 witnesses. The last witness was examined on 3/9/1993. There are 36 adjournments were given to the prosecution for examination of remaining witnesses. How about the
Just a moment. Yes, please read.
Yes. Okay. This case squarely fits in my case. In this particular case, my lord, if several adjournments has been taken and the prosecution witnesses did not appear, and
I'll go through the judgment.
yes,
You sit down. I'll go through the judgment. P25 is less than 7 years,
Yes, less than 7.
huh? Less
than
than
7.
7. Four 38 is what? 438 is earlier 482
Yes. 430.
or 379,
Criminal revision,
397.
revisional power.
Revision petition, no?
Yes.
This is revision petition.
Yes.
So I will need the records. I'll need the records and no point of granting stay because as it is, you don't want the trial to be stalled. So no point of granting stay.
And in this case, what is citation given by the Noble Supreme Court? They are behind the bars. And this petition is not behind the bars.
And that was 3 years.
3 years.
Yes.
Whether
I'll
behind
need
the bars or not.
For a record,
Whatever it is, I'll need the records. Can be disposed, can't be disposed of at motion stage. I'll need the records.
In the meantime.
And no, what is the point of stay? As it is, trial is procrastinating. If the witnesses are coming, let them examine it. Stay won't be granted. Even if the records come, stay won't be granted. Third learned counsel, Mr.
SB list.
S.
B list. SB.
SB Loskar for the petitioner and learned additional PP, Mr. DP Goswami for the respondent's side. Issue notice to the respondent number 1.
For number 1. And the private respondent also I have given the informant.
Issue notice petitioner to take steps to issue notice to the respondents to register post with AD as well as through usual process returnable within 4 weeks. Meanwhile, call for the scanned copies of the trial court record along with the scanned copies of the CD. This is the 256 complaint case.
Yes.
Petition was under section 256. CD nalai. Scanned copies of the trial court record.
Item 5. Highly obliged.
That's it.
Yes.
So the instant criminal petition paying for setting aside and costing the PRC proceeding pending before the CGM at Moriam. Madam, dispute arose between the central secretary and the district secretary in the year 2016-17, madam. For the martyrs family, Assam government sanctioned 5 lakh rupees as ex-gratia to the 855. And among these, my lord, 79 families from the Morigaon district. That petitioner is the central secretary, my lord. He used to help to the beneficiaries and to give the job opportunities for the families of martyrs of the Assam movement since the year 1979 to 85. But my lord, regarding this, my lord, the respondents have misappropriated the money, and in this regard, my lord, he was filed one CR petition and one the representation, but that was not considered. And again, that, my lord, in the year 2020 and another is 2023, 2 numbers of FIR has been filed against the petitioner by the respondent number.
And in those case was registered as PRC case number, my lord, 465, 2020, and another was 861, 2023. Those are pending before the CGM and SDGM at Mori.
You have annexed those
My lord,
FIRs, you have annexed those FIRs here.
my lord, my lord. I as annexion number 1, my lord. And again, the petitioner number, one FIR has been lodged by the deputy commissioner, another was lodged by the SP forwarding to the Morrigan police station. And again, those petition was registered as PRC case number 2 PRC case. And from the PRC case, the petitioner harassing in immensely, innumerable harassment. That is why I filed this instant petition praying for status and was the proceedings, PSC proceeding pending before the PGM as well.
Records will be helpful. Records is required. So going through records.
In the meantime, operation of the proceeding of
On
the
what
PSC
ground?
case may kindly be stated.
No. You don't have a ground here. Will not stay at the operation.
Otherwise, my lord, since 2020, my lord is facing harassment in the.
See, you don't have a ground here. Later, after the record comes, you can place your submission. Now I don't see any ground.
My lord, in the both the FIR, allegation are same, my lord. Informant also same. Is a Rajan Dekai respondent number.
But you have stated that DC has also
I-
filed a complaint against the
My lord,
petitioner.
that was
Then the SP has also
not
filed a
Rajan
complaint.
Deka, my lord, respondent to file the FIR, but that was forwarded by the DC, and another FIR filed by the Rajan Deka respondent to that was forwarded by the SP Muriga, my lord. He is one high-ended man, my lord. That is why he is facing also. And I am the central secretary, and the Rajan Deka is the district secretary. Only to
You have annexed all the 3 FIRs here.
2 FIR, my lord.
2 FIRs, which those 2. Now, what is the present FIR? Present
Hello.
FIR?
FIR is page, my lord. Page 19, my lord.
Please read.
Page 19. Page 19, my lord.
Please read.
FIR against Sri Manik Chandra Devnath, son of late. May I read, my lord?
Yes.
Vrindavan
But
Devnath.
this FIR has been filed by DC only.
That was this. On the basis of written complaint filed by the Rajan Dekar.
Please read. Yes, okay, I understand.
Madam.
Please read, yes.
And against that, my lord, I was filed one.
It's okay, please read the FIR.
This is to inform you that one Sri Rajan Deka, Secretary of Morigaon Jila Porishad, Porial Samanway Rakshi Porishad, has submitted a written complaint against Sri Manik Chandra Devnath for his role in impersonating his identity and falsely claiming his relation with the family members of Shohid late Parikshit Mandal of Jagirot, which is self-explanatory. On the receipt of the complaint petition, I have entrusted Sri Rana Bora, ACS Additional Deputy Commissioner Morigaon, to cause an inquiry and submit his findings. But the said accused person did not cooperate with the inquiry officer. The accused person had submitted a clarification reply.
All right, okay, I read it.
My lord, kindly
No,
see.
you don't
My
have
lord,
a ground.
only
No,
one.
no, this was after inquiry and everything, this case was filed.
My lord, kindly see page
No.
23. That's one proof I want to.
No. Which
give, my
page?
lord. My lord,
Page?
page 23, my lord.
What is the purpose? Because here itself, everything is clear. There was an inquiry there after the FIR was filed.
My lord, again
No,
that, my lord, again that I was filed one bail application before this lordship court, and the lordship court explained it in para 23, in para 4. Notice was issued to the private respondent number 2 to 4.
What are you reading? What are you reading?
My lord, kindly see page 23, my lord.
No, I won't see. This FIR is, this FIR was filed after an inquiry by the DC. The inquiry was done by the ADC. I'll just call for a trial court record.
then notice may be.
Yes,
And
that is what I am planning to do. Learned Counsel, Mr. B. Islam. B. Islam.
mal, yes, it is by the,
Huh?
Telima.
Learned Counsel, Mr. B. Islam, and Learned Counsel, Mr. Soed Salim Ahmed
Right.
are present on behalf of the petitioner. Learned additional PP, Mr. D.P. Goswami is present for the respondent. For the respondent state. Notice has been accepted. You have accepted notice.
From reference number 1 also we have accepted it.
Notices has been
Other-
accepted on behalf of the respondent state by the learned additional PP, so no formal notice is required to be issued. However, sufficient copies to be furnished during the course of the day. Petitioner to take steps to issue notice to the respondent number 224 to register post as well as to issue procedural within 4 weeks. Meanwhile, call for the scanned copies of the trial court record of PRC case number 465 2020, GR case number so and so, arising out of so and so PS case under so and so sections. List accordingly.
Item number 6.
Trial court record along with scan copies of the video CD.
There is an impugn order, your lordship will find at page 62. Here the accused filed one application under section 311 for recalling of 3 witnesses, lordship. Out of 7 witnesses, he wanted to re-examine only 3 witnesses. PW 1, 2 and 3. Here PW 1 and 2 were the seizure witness and 3 was official witness. And therefore he wanted to cross-examine
Case.
NDPS, lordship. Because your lordship will find, just I have given my grounds on ground D, lordship, C, lordship.
You first read the order. Please read the order first.
Page 62. Accused Suraj Singh and Dhira Singh are produced from judicial custody through VC. Hi. They are remanded to judicial custody till next day. Today is fixed for passing order on petition number 12. So I have already heard both sides on said petition. Learned counsel for the defense has filed the above petition stating that for proper adjudication of the case, it is required to recall witnesses, namely Rajesh Surang and Pradeep Koiri and Rajiv Singha, PW3 for the ends of justice. Learned Special PP has raised objection to the above petition stating that the above 3 PWs have been duly cross-examined and there is nothing which supports recalling them. I have considered the rival submission as well as gone through the material on record. From the material on record, in the backdrop of submissions heard, it is found that PW1, 2 and PW3 have been examined and cross-examined in this case. Thereafter, another 3 witnesses have been examined and cross-examined. Section 311 CRPC provides for recalling witnesses for examination only when the evidence of such witness appears to be essential for to the ends of justice, to the just decision of the case. In the instant case, apart from mentioning the 3 witnesses named above, there are to be recalled for proper adjudication of this case. There is nothing more to it in the petition. Hence, in absence of such any such ground being mentioned, which shows that those witnesses need to be recalled for adjudicating evidence for reaching a just decision in this case, as they are already examined and cross-examined duly by both prosecution and defense.
Yes. Where is the petition? Which
Petition,
was rejected?
admittedly, it is not there, lordship. Those things are not there, but I have mentioned in my petition as a ground.
Well, it is not there, then.
But it is mentioned that for the insurance, therefore to show that why it is required, lordship, that things I have mentioned. Because PW 1 and 2, because ultimately,
Ends of
lordship,
justice.
no, because of ultimately the purpose of section 311 is to find out the truth. If I can show it
Well,
for your
where is
lordship,
the petition?
petition is lordship page 60.
Page?
60. Original certified copy 61.
This is the impugned order, page 62.
Lordship.
60 is the petition.
60 is the 61 is the certified copy.
Okay, please read.
That for the proper adjudication of this case, it is very much it need to recall the witnesses, namely Rajesh Urang, Pradeep Kori, Rajiv Sinha for the ends of justice.
What
Is
kind
that-
of petition is this?
Okay,
At least you should have explained.
That I understand. Therefore, I have said that I am not
Some specific grounds there.
So on what ground I'll set aside this order? She has given a pass the correct order.
But today now I have Lordship pointed out those facts. Lordship may kindly see ground D. See, Lordship.
So without setting aside, you can file a
C,
fresh
D,
petition
and
then.
E.
File a fresh petition. I'll set aside this order. You file a fresh petition then.
Lordship, that will.
What do you say?
Not on that petition. Not.
Hmm.
And this C, D, and E, that ground I
But
will.
the order has to be erroneous to set aside.
Not.
Any other suggestion from your side? What to do? This order is not erroneous. How can you set it
Because
aside?
one judgment notice I am citing before Lordship where it is said that Lordship may kindly see that. Small judgment Lordship. Paragraph 8, Lordship may kindly see.
This order is still holder fields. This judgment still holds the
Lordship,
field.
it is Lordship 311
So
and
you see 1999 judgment,
it is always it is not
26 years ago.
no, it was not changed, Lordship.
Huh?
That law probably is not changed till now. Lordship may not changed.
Not changed.
Not
Okay.
changed. That paragraph 8, Lordship may kindly see.
Paragraph 8.
Lordship. Fifth line, Lordship, of paragraph 8. No party.
You get to know from the SCC if it still holds the field. There
Yes,
will
it
be
is.
a
I have got
red
it.
mark, no?
That assistant book I am having.
Okay. Yes, please read it.
No party in a trial can be
Paragraph 8.
Lordship. Paragraph 8, fifth line, Lordship.
Okay, okay. Yes.
No party in a trial can be foreclosed from correcting error if proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence. The court should be magnanimous in permitting such mistakes to be rectified. After all, function of the criminal court is administration of criminal justice and not to count errors committed by the parties or to find out and declare who among the parties performed better.
Yes, yes.
But the thing is that when to the petition by the trial court, no specific ground to there. So on that ground, how can you set aside the order? So
441 BNSS.
440.
What is
440,
441 BNSS?
that is 311.
Earlier?
Now 311.
Now,
Earlier 311.
Earlier
Earlier 311.
528 is 482.
480. Because ultimate purpose of the trial is to find out the truth. If not,
Please sit down. Please sit down. I'll read this judgment, Supreme Court judgment.
Not.
Please sit down. Which paragraph you were stating? Paragraph 8.
Paragraph 8.
You have given the, you want to cross-examine which witnesses?
PW 1, 2, and 3. Out of PW, total witnesses 7. And they are already in custody. No prejudice will be caused to the other side. But if those seizure witnesses and official witness who raided who was member of the raiding team, if they are not examined, that petitioners will certainly be prejudiced.
Where is the ground in the petition?
Ground C, D, and E.
C, D, and E.
E.
I'll dispose it off. But you must mention on which ground you want to cross-examine the, you on specifically you have to mention.
Look.
And more above the, it won't be allowed.
No, not.
To cross-examine generally won't be
No,
allowed.
no.
Okay then. Oh, say 311 to get. How to 311. Oh, 319, CRPC 311. 311. The minute order already. Third learner counsel Mr. A. Ahmed for the petitioner. Petitioner is the accused.
Two petitioners, they are accused.
For the petitioners, Suraj Singh and Hira Singh, who are the accused, appearing in special NDPS case number 107 of 2022. And facing trial for charges under section
Under section 22.
22C,
Lordship.
within bracket, stroke 25, stroke 29 of the NDPS Act.
And Lordship, one thing, Lordship, they are in their petition, because there is no specific ground. That's
Yes,
why
yes. I'll that parts of your
rejected
submission,
their
I will record. The petitioner is aggrieved by the impugned order dated
410. Page 60.
impugned order dated 4/10/2024, whereby the learned trial court has rejected the petitioner's prayer, to recall witnesses, namely Rajesh Urang within bracket PW1, Pradeep Kori within bracket PW2, and Rajiv Singh within bracket PW3. It was held by the learned trial court that in the petition number 960 stroke 2000 or 45.
45.
What is it? 2045 or
Then I
2000?
also, Lordship.
From where that number came? Nalagit. It was specifically it was mentioned by the learned trial court that in the petition under section 311 of the Code of Criminal Procedure within bracket CRPC for short bracket close, comma, apart from mentioning it within important commas দিব নালাগে, কিন্তু italics দি দিব পৰা. Apart from mentioning the three witnesses named above, apart from mentioning the names of the three witnesses লিখি দিয়ে. Apart from mentioning the names of the three witnesses, to be recalled for cross-examination for proper adjudication of the case. There was nothing more in the petition. It was also held by the learned trial court that in the absence of any ground being mentioned in the petition, the aforementioned witnesses are not required to be recalled for adducing evidence for a just decision of the case. The learned additional PP, Mr. D.P. Goswami, has raised objection against the petition. And has stated that the petition under section 311 was vague, whose of no specific grounds were mentioned, assigning reasons where the petitioners have failed, assigning reasons to show to project. Specifically, on which ground the petitioners may be prejudiced if the petitioners, if the aforementioned witnesses are not recalled for cross-examination. It is further submitted that as the cross-examination has been conducted by the petitioners engaged counsel and concluded the petitioners cannot take this plea to fill up lacunae, LSCUNA. It is further submitted by the learned additional PP that the petitioner ought to be dismissed. This petition ought to be dismissed in limine. Consider the submissions at the bar with circumspection. The petition under section 311 CRPC is marked as annexure.
Your Lordship, 10.
Annexure 10 of this petition. Page 60.
60. And 61 is the certified copy.
It is true that no specific grounds or no specific questions have been mentioned in the petition, which the petitioners have proposed to ask by recalling and cross-examining the aforementioned witnesses PW 1, 2, and 3. However, the Lieutenant Counsel for the petitioner has submitted that it has been stated in the petition that the petitioners have prayed for recalling the witnesses under section 311 of the CRPC for the ends of justice. I've also considered the submission of the learned additional PP that the impugned order, that the order impugned by the petitioners is not erroneous, as the petition is a cryptic and a vague petition. It has been submitted by the learned additional PP that the petitioner cannot pray for recalling the witnesses with a blanket and evasive prayer as within inverted commas for ends of justice. The learned counsel for the petitioners have relied on the decision of the Honorable Supreme Court in Rajendra Prasad versus Narcotic Cell, reported in within bracket 1999 bracket close 6 SCC 110, and this judgment still and has submitted that this judgment still holds the field, and it has been observed that paragraph 8. Only paragraph 8,
Only.
but this is about prosecution, no?
Ultimately, both parties, because here the word we use is no party. That paragraph, line number 5, 5th line, Lordship.
No, that entire paragraph is only about the prosecution.
Yes, that
process.
application was filed by prosecutor.
You do not have anything about defense.
Defense, that is there, but I thought that it
No,
will be,
the story starts with cross-examination of defense.
that part is there.
Story starts with that cross-examination of defense only. Side. This is the observation of in that case, no?
Lord.
Not other case.
Not other.
As per relying on the case of Rajendra Prasad and Supra, the learned counsel for the petitioner has submitted that indeed no party in a trial can be foreclosed from correcting errors. Stop. If proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistakes to be rectified as the function of a criminal court is administration of criminal justice and not to count errors. Stop. I find force in the argument of the, I find substance in the I find substance in the argument of the learned counsel for the petitioners. It is also submitted that the petitioners are behind bars. And they are the ones who will be prejudiced if trial is further extended and the witnesses are recalled to be cross-examined. In the wake of the foregoing discussions, without further, I deem it proper to appropriate, to deem it appropriate to dispose of the petition instantly without stalling the proceeding any further. By setting aside the order impugned by the petitioner. So the petitioner may file a fresh petition by specifically mentioning on which points or issues, on which points the witnesses number PW 1, 2, and 3 are required to be cross-examined. And this petition may be considered by the learned trial court in accordance with law. In terms of the above observation, this petition stands disposed of. All right?
Public.
I'll come back after 5 minutes.
In this case, my lord, it's a peculiar case, my lord. I take some time because, my lord, charge sheet was filed, my lord. The informant was agreed with the charge sheet, my lord. So whether a revision lies or an appeal lies, my lord, can it be on next week, my lord?
Yeah.
Because I have been engaged yesterday, my lord. I had some confusion, my lord. Because the case ought to have been registered on the 326, my lord. But the court below, but the investigating agency had filed the charge sheet under 323. And subsequently, my lord, the court also, my lord, acquitted him, my lord, only taking the fine. And when I
Actually, they pleaded guilty. Nowadays, this provision is there.
yes, my lord, can it be on next week, my lord? I'll clear it. Otherwise, I will withdraw the case and file a appeal.
Learned to withdraw.
Next
Cannot withdraw, but
well, I cannot withdraw. My lord. That's why, my lord. Next
maybe
week,
civil you can withdraw, but
yeah, my lord.
learned counsel for the petitioner, Mr. N.J. Doctor, has prayed for adjournment. List the matter on 27.
This way, your April.
Already acquitted. What is the
Yes,
point?
my lord. That too, 1 year back. My lord. I'm all right.
Item 8.
Maybe.
Yes.
There is an NI case, my lord. What happened in this case, my lord? The complainant, my lord, he was examined as a witness in this case. After examination, another witness was examined, my lord. What happened? Complainant, my lord, he was cross-examined also, and he has enclosed his documents as document number 1, 2, 3, 4, 6, 7, 8, and 9. Therefore, he filed one application, my lord, before recording my 131 statement, my lord, that I may be allowed to mark the documents for fair trial. But what has happened, for marking out documents, all right, but court has directed for re-examination. That is not permissible because it was filed.
We have marked the documents now.
See, marking is okay, my lord. Re-examination is different thing. He wants to examine himself.
No, not himself, but cross-examination.
Procedure is already over, my.
No, but after marking the documents, your
lordship may kindly say,
cross-examine.
no, your lordship may kindly say, my lord, the one thing, my, because that is your lordship will find that evidence of annexure 2 is the evidence of the complainant, my lord. That your lordship will find that he has marked the documents as document number 1, 2, 3, 4, 5. Where your lordship will kindly come to page 21, my lord. The certified copy of the bank statement from so and so in the above notice case document number 1. Then similarly, he has marked the other documents also, my lord. That will find there next page. Your lordship will find at page 23, my lord. He has marked the documents. That is a check, bank intimation letter as document number 5. Registered lawyers notice document number 6, 7, 8, and 9. So all documents were marked. Now what has happened? Then we have cross-examining. That page 26 is the cross-examination. Now the cross-examination was done on
10th of April 24, my lord. Now, there also, my lord, he has, there he, though he says that, though I have mentioned the there one notarized agreement was there, that was not exhibited, but we have cross-examined in mind. But in cross-examination, there was nothing which requires any explanation for re-examination, because your lordship will find. And as per document, I will examine on basis of the documents he has exhibited, my. Now what happened, my lord, subsequently, after examination of PW2, then on page 30, he filed an application. It was filed an application stating that he 1/6/2023, my lord, he has filed an application. Says that the above matter filed is placed on affidavit cross-examined by the opposite party. Complainant has page 30, my lord, has filed few documents in the above notice. Complainant in his affidavit through oversight do not mark the documents. Marking was done by document number 1, 2, 3, my lord.
But he was not cross-examined on that point.
I'm not cross-examined.
Document number 1, 2, and 3, 4, 5, nothing has been asked.
Nothing, my lord.
Because it was not marked, that is why. There's one line.
No, I have asked. Your lordship may kindly see.
There's one line asking that you have not substantiated your evidence with documents.
No, that is different. That document is different. That is regarding the agreement. That he has he was number. It did not include. That there was an agreement notarized on 16/3/2020, my lord. That was not a part of the.
So you want a stay?
No. Yes, that's telling me. Your lordship may kindly see. Now he has filed an application under Evidence Act, section 138.
130?
137.
37.
Yes. It is not an application under section 311. That is the thing. If it is serious matter, would have been different. My lord. He has come under section 133, your law 137. That the application your lord will find at page 30, my lord.
Evidence. Yes, please read.
137 says, my lord, that examination of witness by party who shall be called is examination chief. Examination of a witness by adverse party shall be cross-examination. Examination witness subsequent to cross-examined party who call him shall be re-examination. Then your lordship, that important is 138. The witnesses shall be first examined in chief. If adverse will cross-examine, then party calling him so it is a re-examination. The examination and cross-examination must be related to facts. First, cross-examination need not be confined to fact which witness testifies. Now, this is important. Direction of re-examination. When, because the power is on the court for re-examination. The re-examination shall be directed to the explanation of matters referred to cross-examination. The re-examination
shall be yes.
directed to the explanation of matters referred to in cross-examination. In cross-examination, I have never questioned that regarding the admissibility of document. My way of document number 6, I have examined cross-examination on that point only. Whether you have stated in the document number 3 and so on. Now, what is the purpose of filing 137 petition? Whether that is permissible under 137 or not. Because you will also find that the application was filed under 137, Evidence Act, the petition. I am not disputing the marking of document. Nowhere, man. You will also may kindly see the process. How it has been marked, I have examined, I have also processed on that point only.
You are a complainant, no?
I am the accused, man.
You are the accused.
Yes, I have processed the meaning, man. Now the court says, my lord,
the complainant has marked the documents, but later the complainant has prayed to mark the documents.
Now he has only marked as document number 1, 2, 3. He has exhibited them like that. Document number 1, document number 2.
Yes, like as document number. But
one,
now on he wants to exhibit it.
But court has allowed him to. Now your lordship may kindly see the order, my lord. That is page 34, my lord. Now, heard the learned counsel for
page what for?
Page 34, in twin order.
Yes, please read.
Case is called for. The both complainant and accused are present. Heard the learned counsel preparing for a complainant and accused on the petition number so and so on the matter of recalling complainant PW1 for re-examination. Counsel represents complaint submitted at the time of submission of evidence on affidavit. Due to oversight, the documents relied by the complainant were left to be marked exhibit. It is prayed that range of justice complaint may be recalled.
No, he wants to mark the document as exhibit.
Document marked as document number 1, 2, 3. That purpose re-examination is not necessary. Instead of marking them document number 1, it should be exhibit 1. That is typical part. Now, on the contrary, learned counsel of the accused to a written objection randomly opposed to the petition so made by the complainant. The counsel representing the accused has submitted that instant case complaints has already been examined and cross-examined. And complaints filed this case at this belated stage just to fill up the lacuna, thus wait for their petition so prepared by the complaint is rejected. However, having the counsel of either side, I am of the view, if I give an opportunity to complain for re-examination of PW1, same will not be grossly prejudiced. In wake of the above, petition is allowed, number so and so, on the provision of cost of rupees 5,000, out of which 2,000 shall be deposited in the district legal service authority and remaining will be paid to the accused. Now, my question is that if it is re-examination for purpose of only marking, I have no objection, but he cannot add new facts. That is a difficulty. Because marking is a type of review. Instead of they have that document in document number 1, 2, 3, he have mentioned. It should be exhibit 1, 2, 3. By way of application also he can do it. This document number 1, 2, 3 is treated as exhibit 1, 2, 3. Because no new matter has come in the cross-examination. If there have been a new matter in the cross-examination, only 138 says that if their explanation is required, if some explanation is required, then question of re-examination will come. It is a question of explanation doesn't arise because only marking of documents is concerned. Because I have already cross-examined on that document. I have not challenged the validity of the document, nothing. That document doesn't contain because they were already there in the court. He has exhibited it. Because it is a summary trial. That is another important issue.
Then why are you asking for stay? If it is a summary trial.
That's why so the court should not have allowed it, my lord. It was a final stage, my lord.
This petition was filed under 311?
No, not 311.
Under what?
137. Evidence. The 137 also doesn't say anything about re-examination, my lord. That is 138 only.
I don't see any error, honestly.
Yes, my lord.
I don't see any error, honestly.
Honestly, no, your lordship, if he is simply if the re-examination, he simply marks the document, I don't have any problem. Now, if he adds something new, which is not there on the record.
But he is not adding anything new. He is only marking document number 1 as exhibit 1, document number 2 as exhibit 2.
Or if he confined to that part, then I don't have any problem.
How you can apprehend that you won't confine to that part?
No, I'm not complaining, man. I'm the accused.
I know.
Hello, let the notice go, my lord.
You're the accused.
If he appears, my lord, we can at least on that part, the examination may be granted, my lord. That's okay. It's from Jora. It's not given.
I won't stay there.
Because it is fixed on 20, I think on 29th, I think.
29th.
April.
April. Yeah, 29th April, not required stay. All right.
29th 4.
We'll issue notice there.
Yes, notice may be sorted because we will dispose it on that day itself.
Yes. Can dispose it. Maybe with a mutual settlement also, you never know. Learned Counsel Mr. P. Kotori is present for the petitioner. Learned additional PP.
No, state not party. It is a private complaint.
Petitioner to take steps to issue notice to the respondent to register post with AD as well as to usual process or register post?
Register post with.
To register post with AD. Returnable on
short
date at a reader go down. 2nd of April.
Yes.
Call for the, we need the scan copies.
Not necessary.
And never mind, we'll call it.
Yeah.
However, the scanned copies of the trial court record, list the matter on list
Right.
accordingly.
Item 9.
In case if it doesn't, the prayer for interim will consider on the next day.
Prayer for interim stay of the proceedings will be considered on the returnable date. Returnable date.
This is a petition filed for quashing of an FIR, Your Lordship. The facts of the case is that the petitioner is a contractor, Your Lordship. He got the award of a contract, and then to execute the work, he entered into an agreement with one Mr. Ghiyasuddin Ali. After entering into the agreement, Mr. Ghiyasuddin Ali did not conclude the work, and as such, the petitioner filed a title suit in the jurisdictional court for cancellation of that agreement. After receiving the summons, the wife of Ghiyasuddin Ali lodged this FIR at page 61, Your Lordship. Page 61 is the entire. If I may read you. Most respectfully, I beg to inform that I am the wife of Ghiyasuddin Ali, son of so-and-so, resident of so-and-so, that my husband entered into a contract with one Sapan Kumar Ghosh, with the petitioner, and Shankar Acharji to do one railway contract of Lamding division work of rebuilding of bridges work order number so-and-so. As per contract, my husband has successfully completed the work by investing huge amount of money. Later, after completion of the work, my husband asked above named so-and-so and so-and-so for the outstanding amount of 1.35 crore. They refused to pay him any amount. It is stated later, instead of paying the amount, he so-and-so initiated a title suit bearing so-and-so at the TS number so-and-so. So here it is evident, after receiving the summons of the title suit, he lost this FIR, and this was registered under 406 and 420 IPC. Clearly a civil dispute. They have appeared in the title suit as well. I have annexed their WS, and WS of Ghiyasuddin. They are contesting the title suit.
Subcontract.
It is not actually
They were
subcontract.
given the work order.
I was the
You were
initial
given the
person.
work order.
I was given the work order.
But
Initially,
you did not do the contract, then
I
you asked
completed-
Ghiyasuddin to do
I
the.
completed more than 50%, but due to my health issues, it was being delayed. So the railways was pressurizing to complete it. I asked Ghiyasuddin to continue the remaining work. Ghiyasuddin did not do that. Subsequently, my contract got cancelled. After cancellation, I filed a title suit that Ghiyasuddin did not do the work, so he is not entitled to anything under the contract. He is contesting the suit as well. He has filed his WS in the suit. I have annexed that as well. And the wife has filed this, and it is under section 406 and 420. The Supreme Court has clearly stated it is in matters of commercial nature.
So this case is pending at which stage?
This is at Hojai, Your Lordship. Just I have received the summons, Your Lordship.
My lord, here, after the my lord, filing of FIR, my lord, I will completed investigation, my lord, and charge sheet submitted against the both the accused person, my lord. And hereafter, my lord, although it is said that he one each other allegation is one each other, my lord, here from the FIR itself, my lord, it is amount of 1.35 crores, my lord. Huge amount, my lord. As per FIR, my lord, he has invested a huge amount, my lord. Thereafter, they have not paid the amount, my lord. My lord, here at this stage, my lord, Lordship may call only if you notice, my lord, and Lordship may call for a record.
Yes,
my
only
lord.
a notice.
Because I have annexed the title suit plaint as well. The
That
WS
is
as well.
different thing, my lord. Here, my
That is the same thing, Your Lordship. Lordship may peruse the
No,
judgment.
no.
I will rely on.
Will not grant stay now.
my lord.
I will rely on two
We'll
judgments.
dispose it off at the admission
Mine.
stage. No
Because
stay
this
now.
Lordship will consider two things. The petitioner hearing, Your Lordship, is
First
70
of all,
years old.
subcontract, is it legal
Mine.
subcontract? Contract.
Lordship,
Is
I
it
have-
legal
I have-
subcontract?
I have also annexed the contract here,
It
Your
is also
Lordship, the
stated,
agreement.
my lord,
It is not subcontract.
notarial agreement, my lord. How they stand as my lord, notarial agreement?
No.
Lordship I may
No.
submit
stay.
two citations, Your Lordship. Two citations.
What is the point now? I won't stay. We'll dispose it off at the
Lordship,
admission
in that-
stage.
Then my interim prayer may be kept open to be decided on the next day. Your Lordship.
Not exact after receipt of my lord report.
After receipt of record, scan copy.
And also let them appear, my lord.
If it will come before me, I won't grant interim.
Right.
Maybe if it goes to other court, then maybe. I won't grant interim. Learned counsel, Mr.
BJ Mukherjee.
BJ Mukherjee is present for the petitioner. Learned additional PP, Mr. B. Soma is present for the respondent number 1 and has accepted notice on behalf of respondent number 1. Full stop. No formal notice is required to be issued to respondent number 1. Stop. However, subject copies to be furnished during the course of the day. Stop. Petitioner to take steps to issue notice to the respondent number 2 to register post. To register post with AD and may also take steps to usual process, returnable within 4 weeks. Meanwhile, call for the scanned copies of the trial court record along with the scanned copies of the CD. List accordingly. Stop. The prayer for interim stay may be considered on the returnable date.
Item 10.
Lordship, my senior executive CBI is on leg. Kindly pass the word.
Can I give the submission from my side? Basically, a Zimma petition.
CBI case, no point.
He will be there.
Who is he? Hello?
Hello.
We'll hear both together.
I will tell you.
Item 11. Item 11, Lordship. And in this case, your Lordship, petitioner, though named in the what happened, this victim had an affair with the brother of this petitioner. She eloped with the brother of the petitioner. They were married, they lived together for 3 years. Thereafter, some dispute arose, your Lordship. Thereafter, she left and lodged an FIR saying that alleging rape against the brother of the petitioner. And in that petition, all other family members, including the petitioner, was also made an accused. And refer your Lordship to the FIR at page number 10.
Yes.
My humble submission is that about 3 years ago from today, the below mentioned accused number 1, I am not accused number 1, my brother, by giving false assurance that he would get me married with another person, took me away from my home, and he married me against my wish and developed physical relation with me and used me as his wife. As my mother and father are poor persons, hence they did not take any action and kept silent. The accused number 1 kept me in different houses and caused severe sexual assault, and the rest of the accused assaulted me and outed me by giving threat to my life. Although I gave an FIR in this Bandihan of outpost, yet no action was taken, for which I approached the court of CGM Dhubri under section 12 of the Protection of Women from Domestic Violence Act. However, he had taken me on compromise but kept me in a different house and caused natural sex with me and tried to kill me. Being helpless, I took refuge in the house of my father, and while living separately on 14/8/2023 at about 9 p.m. when I went in the backside of my house, that is number 1, by giving threat to my life by showing a sharp weapon, committed sexual relation with me against my will. When I said that I would inform the incident to my mother and father, the case number 1 threatened that he would kill me on the next day, that is 15/8/2023 at about 10 a.m.
Okay, yes.
So, my lord, here is the FIR name accused, my lord. Thereafter, search is also submitted.
My lord, I am submitting. So what happened?
We'll talk about the scan copy.
My lord, people call it here, but what happened? What happened? His brother was arrested. All the other family members, they were never ever asked by the police because they have nothing to do with this case.
Sahajan, in short date. We'll call for the trial court record.
Scan copy, man.
Scan copies of the trial court record.
Tomorrow there is a date for appearance, your lord. So I will appear, your lordship. What I have.
Not required. You are not appearing for so many days.
My lord.
No.
Call
Only
for the scan
I have
copies
appeared, your
of the
lordship.
trial court record along with the scan copies of the CD. It will heri pra ase date eta likhechon. What was the thana? I forgot. অলপ ডেট লম্বা এটা দিব লাগিব মানে ইমান লম্বা দিব লাগে স্ক্যান কপি যে সেকেন্ড এপ্রিল ফাইন লিস্ট অন সেকেন্ড এপ্রিল
What date? 2/4.
You want an earlier date?
Earlier date.
Earlier 28 March.
May it please your lordship. This is the anticipatory bail application in connection with Moirabari case number 179 of 24. The FIR is on page 8.
Let's
At this stage, maybe the city may be called.
call for the CD. List the matter on Moirabari,
PS case number
under which in which
under section
district,
329 4
district, Nagaon niki? Moirabari, Morigaon niki?
Morigaon.
Morigaon.
64 also there, my lord.
Hmm.
329 and 64.
2nd April. Call for the CD. List the matter on 2nd April.
Much obliged.
Item 13.
May please, your lord. The anticipatory bail applications, the council will find the FIR at page 11. Pertaining to forgery of PAN card, madam. May I read the FIR? With reference to the subject cited above, I have the honor to report that as per the above reference DD number, today on so-and-so date, I received credible case secret information from additional SP headquarters so-and-so stating that one Zamir Hussain of so-and-so village is engaged in the making of fake PAN cards and there is a need to investigate the matter on the ground. No, I am not Zamir Hussain. Based on the information received, I along with the police staff so-and-so and so-and-so proceeded to Thakuranbari village in a government vehicle bearing so-and-so number. Upon reaching Thakuranbari, I along with my staff entered the house of Zamir Hussain. Upon questioning, he revealed that he applied for PAN cards for others online from his own house. Accordingly, a search of his house was conducted and 20 PAN cards in silk and envelopes were recovered along with other items listed in the freezer note. Upon further questioning about the names and addresses on the recovered PAN cards, Zamir Hussain stated the names and addresses were fake and that he had never heard of such individuals in his locality. The names and villages mentioned in the recovered PAN cards are as follows. They've given the list of 20 persons. Later, Zamir Hussain confessed that these names and addresses were fabricated and these individuals did not belong to the mentioned villages. He further disclosed that his friend Sajidul Islam is the petitioner. Petitioner. He used to provide him with the names, photographs, and applications of the applicants with false and fake voter ID, epic cards with addresses of Thakuranbari, etc., and other fake documents. Zamir Hussain would then upload these details on the government PAN card application portal using his laptop. Once generated, the PAN cards were sent via postal service to the house of Sajidul Islam in Thakuranbari. After receiving them, Sajidul Islam dispatched the PAN cards to different locations across India, including so-and-so places. These shipments were made over under the name of Ayan Mobile Shop owned by Sajidul Islam in Thakuranbari. Upon further investigation, Zamir Hussain revealed that while uploading the PAN card applications, he was required to attach an Annexure A form signed by Gazetted Officer. However, these documents were forged by the stamp of IC Superintendent and Secretary of JK Arabic College, Jordanga. He admitted that he himself affixed this forged stamp on the Annexure A forms before uploading these applications. The counterfeit stamp and stamp page were also recovered from the possession.
Okay. What is the
Now, my lord, Zamir Hussain has already been arrested. I am Sajidul Islam. I run a mobile shop, mobile and my lord, where this DTP center I run it. And this person, and I will call for the case value, but the fact is that this
call for the CD.
all of
the
them
matter on
shorter date matter before
2nd April.
No, before Eid if possible. If there's no material, then maybe I'll get to enjoy Eid.
This is the Ramzan month, no?
Ramzan month is going on.
When it will end?
It's Eid is supposed to be on 31st, so maybe 28th, 29th. Oh, 28th.
25.
What happened? Deeply observed.
Item 14.
Right, please, madam. This is anticipatory bail application, madam. The FIR is at page 11, madam. What happened, madam? The fact of the case, the petitioner is also a beneficiary who applied for a poverty line 2022. At the same time, one Sumanto Bora of the same village also applied for a poverty. For a poverty line. I have been given the poverty line, but later on, madam, it has come to the, I don't know. I know, madam, he also applied for a poverty line, but I have not seen that he has got the poverty line. But later on, after RTI, he found that the poverty line has been delivered to someone. Now, madam, I am also, madam, that's why I was called for in the case. I given my statement. I appeared before the police matter. Probably the officials may be involved, but I have given my page 13. I have appeared. I have given my statement. Now my apprehension, that I'm called again that you will have to appear whenever you are called. So I may be arrested. That is the only.
You got a power tiller.
Yes, I got my power tiller. I have applied for. I got
You
one.
got one power tiller after
Yes.
this application.
Yes, on my MS application. He also applied for, but he didn't
did
got
not
it.
get.
But later on, after RTI, he found that that has been delivered.
To
So,
whom you?
whom
Maybe
it is
to
not-
you.
Yes. No. My application, my application, I got it. It is admitted fact. I have paid my 33,000, my lord, because others are subsidy. So I have given my statement. I have
What is the
appeared on
cost of one power tiller?
it may be 85,000, 90,000. Other parts
And when you get the subsidy, then you have to pay only 33,000.
33,000. I have already appeared, my
Where
lord.
is the FIR?
Page 11, my lord.
Please read the FIR.
The officer inserts to the officer inserts FIR regarding irregularities in distribution of power tiller under so and so. Sir, with reference to subject stated above, I am to writing a lodge a formal complaint regarding irregularities observed in the distribution of one number of power tiller under the office. It is to be mentioned here in that one beneficiary, namely Sumanta Bora, was allotted one power tiller for the year 2022, but beneficiary later filed a complaint to the district travel affairs plain tribe that never received the said power tiller. Simultaneously, the office also received order dated 23/02/24 from Assam State Information Officer to conduct an inquiry into the matter, and accordingly an inquiry was launched and a final inquiry report was submitted to the Director Tribal Affairs. Accordingly, on so and so, this office received a letter by letter dated so and so, lodge and FIR. All the relevant documents are enclosed here. Given the seriousness of the matter, I request an immediate investigation for your act. It's a formal FIR by the ADC, my lord. I appeared, my lord. Your lordship will find page 13. On 4/3, I was called. On 4/3, I was called and handed over this notice. And I was also asked to appear on 6/3. Thereafter, I'm called again that you may be called anytime. So you'll have to appear. I'm also one of the beneficiaries. I admit, I got my. There may be some. From now, it is found there is some irregularities in one number of power tiller. Sumanta Bora is also from my same village. Both of us apply. This I know, my lord. So at this stage, my lord, I'm praying that, my lord, in fact, my lord, I have already appeared. I have given my statement also.
Yes, yes.
My lord, here I have Lakshmi call for CD only, my lord. Already appeared, my lord.
Anytime they are calling on 6/3 also. Again, they are asking me to appear at anytime. My apprehension is that I may be arrested. And in fact, I'm cooperating the investigation. It is not that. Further, my lord, I'm also a cancer patient. I'm under, my lord, suffering from cancer, and this chemotherapy is doing. So I have annexed my documents. So considering this, indeed, you may be granted. I have no problem, my lord. Let the case they come, my lord, in the system, I may be protected.
What is the offense you have booked?
My lord?
The offense is 420, 419.
Yes, ma'am. 420.
419, 420, 466, 403.
419, 420, 466, 403.
403.
IPC on for the sir.
Well, this case is registered recently, but it is registered in IPC. Is
must be an old police officer.
is not.
419. What is 4 cheating only?
It's cheating only.
By impersonation.
Yes.
Maybe.
That must.
Plausible.
Yes.
Instead of Sumanta Bora, he went.
No, my lord. I also applied. I know, my lord. Both of us we applied. Both of us applied. I know. He also applied. I also applied. My lord. Probably that has been given to someone else by the officials. My lord. I am not commenting here. The officials may be involved. I don't want to comment on that. So
What is
for
the punishment for 419?
419, it maximum 7 years. No? 420 the punishment for 419. This is non-legal matter.
3 years, 419.
419.
427 years.
427.
466 and 40.
420 is not.
Seven years, 466.
Maximum 7 years.
Where is your document relating to your cancer ailment?
But page 14 onward.
2 years, 403. Page 14 onwards.
14 onward. Page 15
Where is
is
it written? I cannot understand.
Page 15 down below, madam. The patients tolerate the chemotherapy well without any complaints. Page 15, my lord, down below, advice on discharge prior to death.
Earlier, that was discharged 1 September 2023.
And later on, my lord, page 18 also. This is by Liver Cancer Hospital.
Page 18.
Yes.
Earlier, 2023.
No, present is also there, madam. Still, he is advised to go outside. Page 19 is remarks chemotherapy. In page 19, my lord, referred from Apollo Hospital for treatment, remarks chemotherapy.
This is also a long time back.
No, this is 23.
Cancer was cured also.
No, it is now he is directed to, in fact, directed to go outside Assam for treatment. Other treatment. The documents, other documents.
All right then. On the ground that he is suffering from cancer. And the offense also.
Okay.
Learned Counsel Mr. J. Payong for the petitioner Ajit Borwa, who has filed his application under section 482 of the BNSS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so section. Third, Mr. B. Sharma, Learned Additional PP Assam. The Learned Additional PP has raised objection against the prayer for interim bail of the petitioner on the ground that he is suffering from cancer. The allegation against the petitioner is that he is involved in procuring a power tiller who was actually allotted in the name of Simonto Borwa. It is Simonto Bora, no? Sumonto Bora. Simonto Borwa, Simonto Bora. It is submitted on behalf of the petitioner that the petitioner filed an application for power tiller distributed on with subsidies, and along with him, Sumonto Borwa had also filed an application. Full stop. The petitioner is not involving in fraudulently procuring the power tiller. Full stop. Based on the application, he has obtained a power tiller. Stop. It is it is further submitted that the petitioner is a cancer patient and he is advised treatment outside the state. The Annexure C series are the documents relating to the petitioner's ailment. It appears that the petitioner may be granted interim bail. Call for the CD, list the matter on. In the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the conditions that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 3, jurisdiction and liquidly visible. On breach of any of the bail conditions, bail or order shall automatically stand cancelled.
Publish.
Date dila.
In this case, the petitioner has purchased 2 vehicles from the registered owners, your lordship, by way of sale deeds. And since the vehicles were on loan, your lordship, it was decided that registration name will be transferred after the loan installments are duly completed, your lordship. I'll take your lordship one of the stated at page 13.
Let us call for a report.
Yes, possibly at this, it will also, I pray before you to issue notice to respond number 2 and 3 because they are the owner of the vehicle.
Owners of the vehicles.
They are the registered owner. What happened? They have sold it to me. And the
No, doesn't matter. We will call for the report and then maybe we can pass an ex parte order also. But now we'll issue notice. Learned Counsel, Mr. MS Lokor, no? Loskor is present for the petitioner. Sobnam Ara Begum Muzumdar, stop. Learned stating special PP CBI is present for the respondent number 1 and has accepted notice on behalf of respondent number 1. Stop. No formal notice is required to be issued to respondent number 1. Stop. But however, sufficient copies to be furnished during the course of the day. Stop. Petitioner to take steps to issue notice to respondent number 2 and 3. Returnable within. You want a date? Returnable on 9th of April. A report is also called for you. Submit the report. A report relating to the vehicles.
Ownership of the vehicle.
A report regarding ownership of the vehicles bearing registration numbers. Where is it?
AS01EX 8657 and S11W 7228.
Is called for, which may be furnished by the CBI. List accordingly.
Lordship, in the meantime, they have taken the custody of the vehicle. The registered owner, they shall not dispose it of your lordship. Observation may be taken.
That ownership lordship is disputed. According to them, they are the owner. Now they are already a registration of this vehicle with regard to some other person.
They won't dispose it, I think.
No, they are disposed because they have already sold it to me. They have taken the money. Now they have one. I was behind the bar. My husband was behind the bar. They have filed a petition claiming that they are the owner. They have totally played fraud with the court, your lordship. They have not revealed that part that they have already sold it to me. The vehicle was seized from my possession.
No, now it is in the High Court. No, nothing can be done.
No, lordship.
No,
Nothing.
nothing.
They are Jimma. Therefore, they cannot dispose it of course.
No, maybe your lordship.
Even in Jimma, there will be some terms and conditions while giving Jimma.
That observation may only be there, your lordship. Obliged.
Your lordship will find page 10. There is some main allegation is against some other persons. Lordship, they were apprehended by the police. They were even interrogated on the spot, but they were not forwarded. Lordship. May I read the FIR, Lordship? Page 10, second paragraph I'm reading, Lordship. On receiving the information, I, along with ASI Gopinath Boro and OP staff, proceeded towards Balajani Sasapani and found out that 8 numbers of male cattle were kept tied in the backyard of the house of Hanif Ali. Hanif Ali is someone different person. Petitioner is Gulzar Hussain. Hanif Ali, so during preliminary inquiry, it is revealed that Hanif Ali has kept the 8 numbers of male cattle in the backyard of his house and on directing to produce ownership details could not show it. It is then learned from Hanif Ali that he, along with the owner driver of the vehicle Tata AC Gold named Hassan Ali, so who was present at Hanif Ali's house, has loaded those 8 numbers of male cattle in the house of Gulzar. So those loadings were done as per allegation that in the house of the present petitioner. Village accordingly, total 8 numbers of male cattle could be recovered and seized from the possession of Hanif Ali in presence of available local witnesses maintaining all formalities as per procedure of law. The seized cattle and suspected Hanif Ali and Hassan Ali were brought to North Salmara OP for further interrogation. During interrogation of the driver named Hassan Ali, he stated that at around 3 p.m. a person named Soiful Saiful of Borpeta has hired his vehicle by fixing an amount of rupees 2000 and directed him to load some cattle from the house of Guljar of Nazasancho, Boigaon, and then deliver the same to Saiful of Borpeta in the early morning. He also disclosed that many a times Hassan Ali, Sanjo, and Hanif Ali is involved in cattle dealing, who is habitually doing such illegal business for a long term. During preliminary inquiry, it is revealed that Hassan Ali.
All right. We'll call for the city.
Lordship, against him only that from the loaded, and Lordship may kindly see. No, Lordship may kindly see that the Jimma petition I have given
This is not a very grievous offense. We'll call for the city and
Fine.
grant you bail.
No,
Twice.
What
Not
will
once,
Lordship may
twice.
kindly appreciate?
Why all the cattle is loaded from his house, not once but twice?
No, from the person who
Maybe,
loaded the
maybe.
vehicle,
I,
and the,
I understand. Yeah, I
they
understand.
were not arrested, Lordship, although they were interrogated. It is from their affair itself shows that they are the main person.
It
Lordship.
is to their intelligence. Why did
Second, my lord.
why didn't they arrest them?
Second appeal, my lord.
Prior to their Lordship, before Eid, Lordship, any date.
Prior to?
Before Eid, the 31st, Lordship, any date may be.
No. This
Only one.
no Eid,
Because
no bihu.
Same is also not there, therefore I am praying.
No. For criminal offences, no Eid, no bihu.
Because
But
against him,
yes.
Lordship,
All
against
right.
him,
All
nothing
right.
is there.
Okay.
Before.
Call for the city, list the matter on 28th of March. And thereafter, I won't be able to give any date on 28th.
Item 16.
That is received 482 bail application. FIR is page 12. Start from page number 12 and vernacular is page number 15.
Please read.
And vernacular is page number 15.
Yes, you can read anyone.
সম্মানপূর্বক বিনীত নিবেদন এই যে মোর
See, just a moment. It's a murder case. Let us call for the CD.
and kindly see
Let's
the
not waste time. Let's just call for the CD.
already
Call for the
granted
CD, list the
granted
matter.
by the learned court below.
So many matters. Let us not waste time. Call for the CD, list the matter.
Kindly
Court
kindly
appeal.
a date may be fixed before it. Kindly
No.
kindly
Murder case. And this is AB, not BA. Also.
it may be CD along with
Court
report,
appeal.
PM report kindly.
CD along with the postmortem report.
Item 17 for admission.
Where is the Lordship? Lordship may kindly adjourn the matter for the day, Lordship.
My lord, date may be fixed after a long time.
Okay.
The number to get.
Learned Counsel Miss
F. Ahmed.
F. Ahmed has paid for adjournment. Learned Counsel Miss
L. Wajida Madam.
L. Wajida is present on behalf of the respondents. List the matter on data review. 22nd April.
22nd April. Deeply open.
Item 18. Item number 18.
My lord, this petition has been filed by the wife matter for enhancing the maintenance allowance.
You are ready?
No, Lordship, my senior has instructed me to call for LCR as the LCR is not received. So kindly that the matter be picked after the
We'll need the LCR. At least I will need the LCR.
Only thing you lordship kindly see the order dated 23/9/2014.
Yes.
2024.
I will give you a date. I'll give you a date. Usually I don't give date in criminal petitions. I'll give you a date.
Date may be fixed.
Yes. Learned Counsel Mr. A. Manov is present for the petitioner. Learned Counsel Ms. Anil Oscar
for respondent number 1
is present for respondent number 1 and has prayed for adjournment as the LCR is not with the has not been called for. Has not been called for.
No.
Okay.
My lord, in the meantime, my lord, maintenance allowance, my lord. Till today, my lord, pending. No maintenance has been paid, my lord. Order has been passed in, my lord, 2023.
She won't be able to help much. It's a senior's case. And who is present for respondent? Learned Counsel, Learned Additional PP, Mr. B. Sharma is present for the respondent state. Call for the this case has been stayed.
No, my lord.
Disposed of case.
Dispose of case, my lord.
Call for the LCR. Call for the trial court records. List the matter on 23rd April.
Item 20.
May I plead your Lordship, I am paying for custody of my vehicle, Your Lordship. I am the registered owner of the vehicle, Your Lordship. My vehicle says due to carrying some cattle, Your Lordship.
Okay, okay.
And
You want us a report? Vehicle was transporting cattle can be handed over to the registered owner.
Press report was called for, my lord.
Uh,
That is not received.
Press report relating to the vehicle seized in connection with this case bearing registration number AS01 RC 3035 was called for but has not been forwarded. Issue reminder, list the
Madam.
matter on
27/8. Maybe. Vehicle seized on
admission আছে না? On 27th, yes. March.
Item number 21.
Met your lordship.
Yes, yes.
This matter came up your lordship several times, my lord. Last product your lordship kindly say, my lord. Today, madam, about 2 years, my lord, is in custody, and only one minor witness was examined. Yes, your lordship will find FIR is dated 7/4/23. Your lordship, 7/4/23.
How many witness?
Total witnesses 9. 9 of them. Then charge sheet on 36/306. Charge framed on
36 2023.
8/11/23. Charge framed on 8/11/23. 8/11/23. And your lordship will find first witness, date was 4/3/24. First date. PW absent without step. Bailable warrant issued. Then second date was 3/5/24. PW absent. Then 24/6/24. PW1 Nijamuddin examined. It's a witness point. Then 16/8/24. PW absent. 23/24 PW absent. 23/10/24. Then 8/1/25. PW absent. Now it is fixed on 21/3/25.
21/3/25.
3/20. There is no chance of coming as per our information, madam. Now I lift your lordship, madam, whether on the face of it, madam. He's a driver of a bus. Public bus, madam. Last time your lordship, maybe remember, madam, your lordship was almost.
I don't remember.
Your lordship has very, my memory is more than us, madam.
No.
But once I remember, your lordship certainly, madam. So almost your lordship was inclined to, madam, on that.
Not at all.
Then they asked for scan copy, madam. I think it is come. Status copy already come.
Out of 9, not to 1.
Yeah, only one, madam.
88 to be exact. Next date is 21/3/25.
There is no
What
chance.
is the article transported?
Article, my lord, that is from the bus, my lord, 50 kg, 50.4 kg, my lord, cough syrup. 420? Yes,
50.4
50.4 kg.
4 kg cough syrup. What is the commercial quantity?
Commercial 25 gram. But it is
25 gram.
1 kg.
1 kg.
1 kg.
420 numbers of bottle of
Yes. Bus was going from that here, madam. In the bus, 4 persons were there last trip, my lord. 4 persons fled away. Maybe they might have known that police is Nakar checking will be there. They left the bus, my lord. They got down from the bus. And when driver has gone, it was checked in the bus. It was one bus, not private car. So I think, my lord, your lordship, because your lordship already decided in the type of cases, my lord.
I'll pass an order.
My lord.
I'll have to check everything.
My lord.
Yesterday,
Your lordship earlier also given expeditious, nothing has been done. That also you ought to keep in mind.
yes, yes. Earlier also there were submissions.
Yes, yes. Earlier your lordship, several times it came before lordship, my lord. I think it is a fit case subject to your lordship.
Let's see.
My lord, I'll leave the lordship.
I'll pass an order.
Last order expedient disposal was there, madam. That not is expedient.
I have rejected earlier, no?
On that ground, rejecting saying that expeditious ground, your lordship order is long back, my lord. Page, order is dated, my lord, 8/2/24. Don't more than 1 month, my lord. 1 year, my lord. That
More
time your
than-
lordship directed to
More than
expedition.
1 year, yes.
Yes, my lord. I leave your lordship.
Case from which court?
Uh,
Karimganj.
Karimganj, session judge. Your lordship's placement.
Hmm?
Lordship.
Yeah. Last, I used
She's
to work,
successor, I think.
I used to work there for 2 years.
Yes.
May I please? My lord, this is regular bill application, my lord. I am behind the bar since,
CD, you have CD?
yes, I am behind the bar since 79 days. I am being a lady, my lord. FI is page number 9. Subsequently, section 103 added, my lord. FI is a page number 9. My lord, already the case number enlarged on anticipatory bail, my lord. Now I am behind the bar for, my lord, 79 days. May I read the FI, my lord?
Yes, please read.
The humble submission of the informant is that on 22/11/2024 at about 7 p.m. the accused number 1 called my mother, namely Runufa Khatun, at their house to show the guys who were playing game in mobile phone. And after that, the accused number 2 who hit that iron rod in the fire pit and stepped at the stomach of my mother and injured her seriously. The accused number 2 also assaulted her mother in her head by rod. My mother is still going treatment at GMC. My lord, postmortem report has already been done, but cause of death cannot be ascertained. So, my lord, 79.
That is not to be taken.
My lord, only 11 days.
It is kept
Remain
pending.
to my lord.
Otherwise, eyewitnesses there. Yes, but
So reject it or I can wait for report.
My lord, I am being a lady, my lord. This is month of Ramzan, my lord. Only, my lord, 11 days to go. During this period, my lord, the investigation agency
The
never
mother of,
visited the
you
jail
see
to,
that mother, an old
My-
lady,
my lord,
mother that
not
informant.
died, my lord, not died on the issue, my lord. My lord. So,
We'll
there is
call,
no
wait
intention.
for the viscera report.
79 days, my lord.
Which CD is ordered without the viscera report. Call for the viscera report, list the matter on 90 go India. 90.
My-
No, 90 days over, 25th of March.
Almost.
Hmm.
Almost.
Yeah,
89
yeah,
days.
90 go area. CD to be
20
retained till 25th of March.
25th. 25th.
Kiman dila? 25th.
25th.
Alright. 28
No,
March.
then my mandatory period will be over. Tell me 25 days, 89 days.
89 days.
That is month of Ramadan is going on. My lord, 25th, my lord.
28 then not to have sent back the city.
No, no.
On 25th.
It's everything is complete. There are witnesses. We need
My-
only the viscera report.
my-
You retain the CD.
Almost the investigation is in ripening condition. Except collecting the
No, no,
viscera,
no.
my lord.
Submit koi diya. 25th.
25th.
submission that the petitioner is the sole breadwinner of his family and he has to take care of 2 minor children. Stop. I have also considered the submission that the petitioner is a local resident and he is not a flight risk. Considering all aspects, petition is allowed. The petitioner is enlarged on bail of rupees 50,000 plus security of like amount to the satisfaction of the learned trial court under the conditions that the petitioner shall cooperate with the trial. Number 2, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. On breach of the petitioner, and the petitioner shall not try to influence the witnesses or exercise threats to the witnesses. On breach of any of the bail conditions, the learned trial court is at liberty to immediately cancel the bail granted to the petitioner. Any short submission? Adjournment?
I'm for item number 29, my lord. I have checked the office number, my lord. 13/3/25, my lord. The trial court record has not been received, my lord.
The trial court record as called for is not received. Issue reminder, list the matter on. This is, I think, trial. Oh, okay. Oh, NDPS case.
Yes, my lord.
Item 32.
Is they not in time?
CDS call 32. CDS call for is not received. Issue reminder, list the matter on.
From Lakhimpur long day.
Interim is there.
Interim order shall remain in force till then.
Item number 28, my lord. Injury report was called for, but injury report has not.
What report was called? Injury report.
It is here already written, my lord.
CD already retained.
Written, my lord.
Then we'll send it back.
My lord,
Otherwise, investigation will be stalled.
my lord, 62 days, my lord, bail application.
What case under which
And-
sections?
Under section, my lord, 126 to 118 and 109 BNS, my lord.
Or that injury is on grievous injury as suggested.
My lord, has suggested. What injury report, my lord, prevails, my lord, whether it is grievous or.
AB? BA or AB?
One bail application, my lord, and another, my lord, AB, my lord. It is taken along with the BA, my lord. Item number 28. No,
AB is
no,
disposed
it
of,
is
I think.
wrongly, my lord, wrongly reflected, my lord. 121 of the 225.
DO wrongly reflected cases.
Interim was there.
In the AB?
So far as petitioner number 1. Only 121 oblique 225, my lord.
AB to लिखी दिवस ना. The CD is received without the injury report. Send back the CD. Call for the up-to-date. Call for the CD along with the up-to-date CD along with the injury report. List the matter on.
Okay, my lord, 20.
From which place?
Lakhimpur, 27.
It will take some time. 2nd of April. 2nd of April. No, do
Interim order, my lord.
interim order shall remain in force till then. A to AB2 or BA2 लिखी दिवा CD is received without the injury report. Send back the CD. Call for the up-to-date CD along with the injury report. List the matter on 2nd April.
Oblige.
Item 36.
36.
CD has not.
CD as call for is not received. Issue reminder. List the matter on.
Interim is there.
Interim order shall remain in force till then.
Oblige.
May I please, your lord? In this case, my lord, totally I am not on merit. 56 days behind the bar. All sections are mandatory period lordships for 60 days. Now 56
You
days
have a
already
CD?
behind the bar.
My lord. After some time, my lord, we have done for the matter.
Oh, yes.
Let the CD come.
My lord. After some time.
Item 27.
For office note, my lord, LCR has not been received till now. So, my lord, let this matter come up on 25, my lord.
LCS call for is not received. Issue reminder. List the matter on 25 or hobos or not? Better get the date diyo.
3.
3rd April.
He has come, my lord, 23 and.
No, no, oh, full name.
Supplementing this, item 50.
My lord, in this case, 36 submitted, my.
You'll have to, if you want, you'll have to apply for bail there. Learned counsel, Mr. G.R.A. Motaki is present. CDA, learned additional PP, Mr. B. Sharma submitted as charge has been laid against the petitioner
Right.
being CS number.
25 of 2025, dated 28/2.
The petitioner is able to approach the jurisdictional court and apply for bail, which may be considered by the court in accordance with law.
51.
Can you take it after? If senior counsel is to take care of it.
Allegation is that, my lord, we are actually dealing in cars, second-hand cars. We collect some documents from our customers, and these documents we have distributed, we have given to somebody else, and they have misused it. This is the allegation, lordship. Totally, lordship, I am not on merit in this case. 56 days behind the bar, 60 days mandatory period. On the basis of length of detention, I am seeking this bail.
My lord. I don't make even look in the page 12 of the FIR.
Yes.
Some portions, my lord. But, 12 of this, my lord. First one, my lord, both are the arising out of the same affair, my lord. 22.
Yes.
My lord, based on credible information received, it has come to light that two individuals have been involved in an organized racket engaged in fraudulent activities. These individuals reportedly collected corporate bank accounts, checks, linked ATM cards, Aadhaar cards, and SIM cards, which were subsequently handed over to an organized gang of cyber criminals. They used these accounts to conduct illegal transactions through unauthorized gaming applications, defrauded others, and collected commission from these illicit activities. Now, my lord, here, two persons were apprehended. One is, my lord, there is a FIR named Moyaz Ali. Another one is, my lord, Ruhul Amin. Now, in the, my lord, this instant petition, these are the petitioners.
In item number 23.
Item number 23. And, my lord, in the item number 24, another one, Mr. Masood Mamun, my lord.
His name was not there originally in the FIR.
My lord, these are the acts, my lord. They are collected some, my lord, from the CDET reveal, they collected some bank accounts, my lord, using various kind of fraud. And then thereafter, these transactions were being made, my lord. My lord, there is serious implication in both the cases, my lord. My lord, may kindly peruse the CD, where even part I have like marked.
Length of detention can be considered right.
Yes, no, the 56 is already behind the bar. There is nothing.
Our learned counsel, I'll consider length of detention.
My lord.
This is 60 days.
60 days offense.
statutory
All
period.
sections are 60 days.
Our learned counsel, Mr. G. Somo, for the petitioners, to 23 to dozen petitioners who have filed this application under section 483 of the BNWS 2023 as they are behind bars since 22/1/2025 in connection with so-and-so PS case under so-and-so sections. E2 whole 29/1, huh?
Yes, Lord.
It as on 24 to 29/1. The allegation against the petitioners is that they have been involved in defrauding others by unauthorized gaming through collecting corporate bank accounts, checkbooks, ATM cards, Aadhaar cards, SIM cards, etc. And thereafter being involved with an organized gang of cyber criminals. The learned additional PP, Mr. K. Bosher, has submitted that they are incriminating materials in the case diary against the petitioners and they are not entitled to bail as the offense against them is of grave nature. Full stop. I have scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioners. The investigation has progressed substantially. It appears that custodial detention may not be required for further progress of investigation. The petitioners have pledged to cooperate with the remaining part of the investigation and to abide by any stringent bail conditions if imposed upon them. The petitioners, being local residents, are not flight risks. Considering all aspects, petition is allowed and the petitioners are enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the Elaga Magistrate, stroke jurisdictional court at Borpeta under the condition that the petitioner shall appear for the IO on every fortnight till completion of investigation. The petitioner shall not leave the jurisdiction of the court without prior permission. The petitioner shall refrain from such activities with which they are alleged. He is liberated. On breach of any bail conditions, the learned jurisdictional court stroke Elaga magistrate is at liberty to immediately cancel the bail granted to the petitioners.
Deeply obliged, man.
Send back the CD.
Deeply obliged, man.
No, বেলেগ বেলেগ কৰিব এটা আছে একে নালাগে এটা দুটা আছে
Item 49. For hearing.
This appeal is preferred against the judgment of the learned Session Judge Bongaigaon Lordship, whereby the appellant has been convicted under section 341, 376 IPC and sentenced to 10 years imprisonment under section 376 and 1 month under section 341 and fine lordship. Here, the petitioner case
341 and 376.
341 and 376.
341 1 month.
1 month and 376
10 years with fine. Yes.
Your Lordship, the prosecution case was that the girl and the appellant was in a relationship Lordship since 2017. Thereafter, in 2020 Lordship, she was engaged to PW2 Lordship, one Ashok Roy, in December 2, the 2nd December, engagement was performed. And thereafter, on 28 December 2020, Lordship, as per her statement, that she was the appellant forcefully took her to the hotel in the Bongaigaon, and without her consent, Lordship, under threatening her that some nude, earlier Lordship, she had sent some nude photos, her photos, Lordship, in WhatsApp to the appellant Lordship. And it is her statement that she has threatened that he will make these photos viral. Physical relationship was established in the hotel, and therefore after that they performed marriage with PW2 in February 21. After marriage, her husband came to know about their relationship, and he also came to know about the photos Lordship from her mobile. He found this photos.
Mm.
And under his pressure, he has lost this FIR, alleging that the appellant has committed rape on her on 28 December 2020. And police registered the case under section 341, 376. The suit was also filed under same section, and trial was started. During trial, 7 witnesses were examined. And the learned trial court mainly relied on the PW1, the girl, on the statement of the PW1. The other witnesses were not considered. The medical, in the medical evidence, it was stated that nothing has been found regarding the rape being committed on the respondent number 2. Only on the basis of the prosecution witness number 1, he was convicted.
Mm.
Now, Lordship, case 51 is the FIR, Lordship.
Yes.
This is the type copy.
Yes.
Where it was. It is subject is objection. It is in vernacular. It is written as apopti, not as azahar or something like this. With due respect, this is stated on 28/12/2020 approximately. While I was going to my home from Bongaigaon, one Sri Dhanjit Sutradhar intercepted me at Jatangka, Sirang, and behaved indecently with me. He then forcefully taken me in a car without my will to a hotel at Bongaigaon by threatening to kill me. He forcibly raped me in the hotel and captured photos in a mobile phone and threatened to kill me if I happened to tell the incident to my parents, and as such, having left with no choice, I kept the incident secret. I was married to one Sri Ashok Rai of Bizni, Gosaigaon on 2/2/21. Since Dhanjit Sutradhar used to forward indecent photographs in my mobile phone, even from prior to my marriage, my husband came to know about the same. Dhanjit Sutradhar was threatening to make the indecent photographs viral. On coming to know about the incident, my husband informed the same to my parents. At last, having left with no alternative, I am compelled to approach the police. Your Honor is therefore requested to investigate into the matter and take appropriate steps. This is a FIR, Lordship. And therefore, Lordship, it is registered under section 341, 376. Therefore, Lordship, page 55, this is a testimony of the PW1, the victim girl. Yeah, Rita.
Yes.
I am complaining of this case. About 1 year back, I got married with Ashok Kumar Roy. I was introduced with the accused Dhanjit Sutradhar in the year 2017 through Facebook. Love affairs cropped up between us. As pressurized by the accused, I sent some of my naked photos to the WhatsApp of the accused as I have love affairs with him. After receiving the said naked photos, he tried to blackmail me and threatened me to upload the same in the Facebook. He was asking for more naked photos, but I did not send. He offered me to have sex and intercourse, otherwise he would upload the naked photos in the Facebook. My mother is a school teacher. One day, I went to drop my mother by my scooty to her school at Bhadragaon, and while I was returning after dropping my mother at Bhadragaon on the road, accused snatched away my mobile and key of the scooty as I gradually disliked him for his bad behavior. At that time, one nearby person of the same village, after witnessing the said incident, informed my cousin brother, Opan Choduri, and Opan Choduri made phone call to my mother, and Opan Choduri came to the spot and took both of us in our house. Mother also came, and some family members of the accused also came to our house and took him to his house. When I came to know about his bad character and bad behavior, I tried to avoid and block his phone number. However, he kept continuing to send messages to me by different phone numbers threatening to kill and threatening me to kill and my parents. In the meantime, some proposal came to our family for my marriage, and my marriage was fixed with one Ashok Roy. On 2/12/2020, ring ceremony was performed for my marriage with Ashok Kumar Roy. After performance of the ring ceremony, accused was constantly disturbing me, and he threatened me to send my previous naked photos to my proposed husband and in the Facebook. He also told me that I was not doing right thing being married with Ashok Kumar Roy. On 28/12/2020 at about 3 p.m., I was coming to my house by an auto.
It is going to
Day
execute.
after tomorrow then.
Lordship, I place only state lordship, nothing more lordship. I'm ready to pay the maintenance
I
to
will
my
have to think about it. Day after
lordship.
tomorrow.
I'm paying the maintenance. I'm ready to pay the maintenance.
You
to
won't
my
be
son,
arrested, don't worry. Day after tomorrow, did you do? Jodiya time hoy.
Lordship,
No, I won't be able to take it.
I can tell you, madam, there is correct, small correct.
No.
Madam, this I am, madam, this small correction, cross title, madam. One correction.
I am in bail.
Yes, madam, bail, madam. Small correction, madam.
No.
I am parliament, madam.